Hello and welcome, everybody. I am Dana Sparks. I am the director of the Real Estate Academy of America, which is the school offering this class for CE credit. And I am also the broker of Maximum One Greater Atlanta. The only reason I tell you about my other job as being a broker is because we are dealing with contracts. Now, today's class is the 2025 Georgia Association of Realtors, or GAR, brokerage agreements and customer acknowledgements. I am what they call a non-competing broker, meaning I don't actually help the public anymore in terms of buying and selling. I manage our companies, I direct the school, and I teach and I deal with contract issues that have some interesting questions or issues, and I deal with co-op agents and co-op brokers and the public with things like that. But I just wanted to let you know that I do see contracts, I do see brokerage agreements on a regular basis. We have a separate compliance broker that sees every contract. But even though I'm not actually interacting with the public, I am very familiar with the contracts, with some issues, with questions. And so just wanted to give you a little bit of context before we dive in. We do have a lot to cover, even though today's class is only on the seller and buyer brokerage agreements and the seller and buyer customer descriptions. And I'll explain that a little bit more as we go along. But we do have a lot to cover. And bonus for you guys. The I was received a sneak peek copy of the changes that the GAR contract package is coming out with, available to all of y'all as agents on June 1st, 2025. And today, this recording is as of May 6th. So I'm not going to go over all the changes. I'm going to do a whole video series on that. I do have a YouTube channel, Real Estate Made Crystal Clear. I'm going to do a whole video series on the mid-year changes. But there are two changes to the brokerage agreements, and I will cover those. You guys are going to be the first ones to see them. I just got them yesterday, so the timing is perfect. My goal in any class is that the 3 hours goes by very quickly. The CE credits are a bonus, and that you guys really learn something that you can use in your ongoing day-to-day career interacting with your public whom you are helping and blessing with your real estate license. My other goal of every class is that I pay glory to God who has put me in this position to be able to hopefully impart to you guys something that in turn can help you bless others. So, with that, let me dive in. And I think my notice to students will explain a lot of things. We have a lot to cover, even though it's just a few documents. And let's dive in. So, I'm going to start off. I'm going to share my screen. And um, excuse me, let me open up the chat so I can see what you guys are asking. Hopefully y'all are good to go. All right. So today's class is the 2025 Georgia Association of Realtors, or GAR, brokerage agreements and customer acknowledgements. It is GREC course number 78107. I am the instructor. There is my email address. Please write that down in case you have any questions later. And it is 3 hours of CE through the Real Estate Academy of America. So the school, excuse me, we have to renew, schools have to renew just like agents and brokerages do. Our renewal is due the end of 2026. And this is the course number 78107. Again, I'm the instructor. This is an approved remote or virtual broadcast of an approved classroom class. For any virtual class that you take, you cannot take more than one at a time, regardless if it's from the same school or different schools. And the easiest way to think about that is if you were attending a class in person, there's no way you could take um, more than one class at a time. The way our school was approved for attendance is via the chat function. So I will ask you 3 times. Again, if you've already done it, you do not have to do it again. But I will ask you 3 times to type in your name, your license number, your email address, and your phone number. Again, your contact information is so that we can get in touch with you should we have any issues with your license number and recording your CE credits. So at the beginning of class, when we come back from break, and right before you end. Additionally, I will ask questions and ask you to type your answer in the chat. If it's a rhetorical question, I'll ask you. I will prompt you if it is something that I want you to type in the chat. In the interest of time, even if I have already given the answer, go ahead and type in your answer in the chat. That way we can demonstrate to GREC that you were actually here and paying attention and didn't just turn on your computer and walk away for 3 hours and come back. And for any CE class, you may only get 3 hours credit for a course number. That's not per topic. You can take more hours on the GAR brokerage and customer agreements, but it is this course number through this school. You can only get 3 hours CE credit once every 12 months. And there is no recruiting. If so, please report that to me, the coordinator of our school, Heidi Kelly. She is also the one who records the CE credits, or directly to GREC. All right. We are going to do just a little bit of background regarding brokerage relationships. And the first thing I want to let you know, in the GAR, this is the very bottom of the purchase and sale agreement. You are required to disclose the actual brokerage agreement, and that is required by license law. In other words, if you are working with a public person as a client, you are required to disclose that you have a client relationship with either that seller or that broker, or that buyer in any contract. Now, the GAR contract and the purchase and sale agreement has fill in the blanks at the bottom, as does the RE forms. But if you are an agent and you are helping a buyer, let's say buy a new construction or working on a HUD contract, Fannie Mae, Freddie Mac, an investor written, an attorney written contract. If you are working with that buyer, let's say, or the seller as a client, and there's not a fill in the blank, you need to add that in there per license law that such and such broker is working with buyer as a client. This is the license law. It's unfair trade practice, Georgia Code 434025B30. Failing to disclose in a timely manner to all parties in a transaction any agency relationship that the licensee may have with all the parties. Now, what do you do how do you fill this out if you are a buyer's agent and you're writing an offer? You think at first, I have no idea what kind of relationship the seller's broker has with the seller. Well, here's a clue. If you have found the listing in either FMLS or Georgia MLS, now the other MLSs here in Georgia I'm not as familiar with, but with those two, if you have found a listing in either one of those two listing services, you know that that seller is working with that broker in a client relationship. Not only that, they have signed an exclusive seller brokerage agreement. How do you know that? Because the membership rules of FMLS and Georgia MLS are such that in order for that listing to be in those services, the seller is required to have signed an exclusive seller brokerage agreement with that broker. Now, regarding dual agency, designated agency, dual agency is allowed by Georgia law, but your broker may have a policy prohibiting that. Customer relationship. What about the customer relationship? Well, in Georgia, your public for real estate, your public people are by default customers of your broker. They don't have to sign anything to be a customer. By default, they are customers. GAR has documents that describe the customer relationship that they have with your broker. What about if they are a client? In Georgia, the client relationship is contractually driven. In other words, a public person may only be a client if they sign a brokerage agreement with your broker. Seller brokerage agreement for a seller, buyer brokerage agreement with a buyer. I'll get more into that a little bit later. Very, very basic review of the types of agency. Single agency means they have signed a brokerage agreement and the broker, all contracts are in the name of the broker. All compensation is earned in the name of the broker. You as an agent are an affiliated licensee affiliated with your broker. So all of these relationships are relationships the public has with your broker, meaning the brokerage broker. So single agency means they've signed a brokerage agreement and they have a client relationship. The broker has a client relationship with the buyer or the seller. Dual is legal with disclosure and consent. Again, check with your broker's policy. That means the broker has a client relationship with both the buyer and the seller, and there's only one agent working with both sides. Designated agency, one broker, but two agents. And the broker has a client relationship with both the buyer and the seller. Two agents. One agent has signed a brokerage agreement with the seller. The other agent has signed a brokerage agreement with the buyer. Now, you may also, again, check with your broker, but you can also have both sides of a deal without it being dual agency. Again, this can be tricky, but check on your broker's policy. What would that look like? The broker will have signed a brokerage agreement with only one of the parties, and therefore they are in a customer relationship with the other. This happens very frequently. For example, you have a listing, you've signed an exclusive seller brokerage agreement with the seller, you get a sign call. So you have a client relationship with the seller, you get a sign call. That buyer is not working with a broker. You show the listing, they end up wanting to buy it. Right there, you can have both sides. And if the buyer does not sign a buyer brokerage agreement, that is both sides without it being dual agency. Again, check with your broker if that is allowed. Now, Beretta laws. I am not going to cover all of these, or that's a whole nother class. But in Georgia, this is Georgia law, Georgia Code 6A1, brokerage relationships in real estate transactions. We lovingly refer to this as Beretta. I am just giving you, I'll show you where you can get the handouts also. These are the laws in Georgia that govern the brokerage relationship in real estate transactions between the public and your broker, and what the duties are, what the responsibilities are, dual agency and ministerial acts, what you can do for a customer. Again, I have this as a handout with hyperlinks where you can read all of that for yourself. Just wanted to let you know where that law is. And basically, this also says that a public person is not your client unless they sign a brokerage agreement. GAR has wonderful document for us. It is CB01 called the ABCs of Agency. This is, I highly suggest, agent point of practice. I suggest that you have this document, GAR, again, CB01, Consumer Brochure 01, the ABCs of Agency, as well as the next handout that is courtesy of our school that goes through ministerial acts. I suggest every agent have this and present it with all of your public people so that they understand the nature of the legal relationships they have with your broker. This is if your public person signs a brokerage agreement, which we're going to cover in depth in just a minute, what the nature of that relationship is. And it describes who brokers are, brokerage generally, client versus a customer, um, broker client relationships, seller agency, landlord agency, buyer agency. Again, broker customer relationship, it goes on and on. This is a great document. You definitely need to read it and understand what it is. It describes dual agency, designated agency, so forth and so on. The other handout, again, as a courtesy that I give to all my students. Again, check with your broker before giving anything to the public that your broker represents. But this is a description of ministerial acts. So when you're working with a client, you can perform agency type duties, conversations, so forth and so on. When you are working with the public as a customer, you may only perform ministerial acts. Well, what does that mean? We've heard that. And some of you I see on here have been licensed for years and years and years, and you knew what it was when you got your license. But you may have forgotten sort of what that actually means because you develop a relationship with your public person. Well, there's a lot of information here. One is from the Georgia Real Estate Commission's newsletter, even though it's from 2021, still very relevant regarding what a ministerial act is, as well as Georgia Real Estate License Law, Georgia Code 4341, defining ministerial acts, Beretta laws that we just covered, that talks about ministerial acts. Beretta gives examples of ministerial acts and what an agent and a broker, the types of actions and conversations you may and may not have with your public person with whom you are working as a customer. And GREC Rule 520-1-.02 again has definitions regarding what it is to be a customer, what it is to be a client, what discretion and judgment are that you can use with a client, not with a customer. And again, more of Georgia law under the commerce and trade laws. And again, more information about ministerial acts. So these two documents, again, as an instructor, I highly suggest you have both of these documents with the materials you present to your public buyers and sellers. And especially if you are in a situation where you have the opportunity to have both sides of a deal, the party that you are working with currently as a customer, you want to explain to them what the difference is between them being a client and a customer. And again, this is very tricky, and check with your broker. But as an instructor, I'm going to say you always want to give a cut. If you have both sides of a deal, the customer, you always want to give them the opportunity to be a client. Now, if your brokerage does not allow dual agency, then they would have the opportunity to be a client of another agent within your brokerage, making it a designated agency situation, or perhaps becoming a client of another broker. Again, you want to make sure they understand what that representation is and is not by being in an agency relationship, a client relationship versus a customer relationship. Now, I will parenthetically say that representation is completely different from compensation. In other words, if you are working both sides of a transaction and let's say you have a listing, so you've got a seller brokerage agreement signed with the seller, you've got a client relationship with the seller. My same example, you get a signed call that buyer wants, no, we're not working with a broker, they want to buy the house. You talk to them, you have this discussion with them, tell them the difference, how you can relate to them if they are a client versus if they are a customer. They're like, nope, I'm good. I'm willing to be a customer. You write up the deal, you get it all negotiated, buyer and seller negotiate, you get a binding contract. You're going along, and then that buyer who is currently your broker's customer says, hmm, you know, I think I want my own agent. I think I do want a client. I want to be a client of a broker and have somebody look out for me in a client manner rather than interacting with me as a customer. If the deal is all done, your public buyer is absolutely entitled to become a client of a broker. And if they choose a separate broker, that's fine. However, at this point, the deal is done. The binding contract is done. Buyer and seller have negotiated. So a buyer is absolutely, in my example, is absolutely entitled to the representation, but they are going to have to pay for that representation themselves because the deal has already been negotiated. Versus if, again, same example, you get a sign call, buyer wants to buy the house, you have this discussion with them, and they're like, no, I think I do want a broker to represent me. At that point, if you have not negotiated a deal, then compensation gets negotiated. If that buyer goes and chooses another broker, compensation gets negotiated just like it does in any situation. But my point of that is that compensation is different from representation. And you can never deny a public person representation if they choose that. It just depends upon when in the transaction they choose that, whether they are paying for it or it gets negotiated within the terms of the transaction. All right. Let's now dive in to the seller brokerage agreement. So, the majority of what I am going to cover is the version that came out January 1st, 2025. And let me just show you down here. You will always know if you are dealing with the version of the contract form that came out in January or if it was a revision. And again, you guys get a sneak peek, but see here at the bottom, it says 1/1/25. That means this is the version that came out January of 2025. This is what we're going to cover. There's just a couple of changes. See the bottom of this? This says 6/1/25. So you will know which version you are working with. But let's go back over here. This is really hard. Is this hard to read? It's a little tricky to read. I'm going to see if this does better. Hang on one second, guys. Let me see if I can. There we go. I think that's a little bit easier to read. All right. So this is not going to be, we've got a lot to cover. This is not going to be a fill in the blank 101. I'm going to cover a lot of the main concepts that you need to understand about completing a brokerage agreement. If you have any questions, I will be more than happy to answer them at the break. Type them in the chat, and if it's relevant, I will go over it. If not, we'll deal with it after the break. So again, this is the exclusive seller brokerage engagement agreement. It tells us right here, based on Georgia law, state law prohibits broker from representing seller as a client without first entering into a written agreement with the seller. So again, it doesn't matter how long you've known somebody, if you've done a gazillion deals with them, if you know everything about their financial portfolio, if you've been at their weddings, at their parties, whatever. They are not your broker's client in Georgia with respect to real estate unless they have signed a brokerage agreement. Now, if they are a past client or a friend or a business partner, that would be a material relationship, but not necessarily a client relationship. And why are you saying that, Dana? Well, because Georgia state law tells me to tell you that right here. So again, it says, okay, seller, when you sign this, you are saying that you are exclusively working with me as my client, and I am allowed to use discretion and judgment in helping you list and sell your home. You identify the property, and in Georgia, a street address is not enough. Georgia is one of the original 13 colonies. We have lots and lots and lots and lots of claims to our land. Land has changed hands many, many, many times. And in Georgia, especially in metro Atlanta, we have a lot of similar names. We've got Peachtree Road, Peachtree Court, Peachtree Trace, Peachtree Circle, Peachtree Court. So sometimes it can get a little bit confusing. So you absolutely need a legal description. Again, it is required in addition to an address. Where do you get a legal description? Well, the best source would be the warranty deed that the seller has that they got when they purchase the property, or if they've quit claimed it or anything like that. But the legal description will be included in the warranty deed, or there is a website called gsccca.org. That stands for Georgia Superior Clerk of Court Co-op Association. Woo! It's a mouthful. And that is a cooperative of not all, but most of the counties here in Georgia where they put all their online documents together. You guys, that is a fabulous resource. Not only does it have legal descriptions, it's got lien information and mortgage information, and you can search through that. You can tell how long someone's had a mortgage and all sorts of information on there. That is a paid site. I don't know what other brokers do, but I know at Maximum One, we do pay for that for our agents because we feel like it is so valuable. But you'll have to check with your own broker, or if you do a lot of listings, it would be well worth it to pay for that yourself. You can always get that information, the legal description, from a closing attorney or the online tax records. The uh, um, The best source would be to attach an actual copy of the warranty deed that does contain the legal description. The next best, most reliable legal description is in the warranty deed book and page. Now, this last section, landlord district section, Georgia, GMD stands for Georgia Militia District, lot, block, unit, phase, blah, 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 blah. That is the least reliable, because most agents, if you're filling all of this out, you don't have all the information. So if you just have land, lot, and district, the land, lot, and district can be a huge area and doesn't necessarily identify the specific parcel of land that a seller intends to sell and a buyer would intend to buy. I will tell you, however, that it is very helpful for your brokers, for your buyers and sellers, and for your closing attorneys if you do go ahead and put in the subdivision name. Now, if the property is a condominium, you will need this information. And just as a note, a condominium refers to ownership. A lot of our public think that a condominium or condo refers to a property being attached or not attached. And typically, the public thinks a condo is an attached single level unit or housing. And they think of a two-story or more attached housing as being a townhome. But condominium doesn't refer to style, it does refer to ownership. Condominium ownership, typically the owner owns the inside of the property as well as having an interest in the common areas. The opposite of condo ownership is fee simple, meaning if you own a property in a fee simple versus condo ownership, you own the whole thing inside and outside. So moving along, you're going to fill in the list price. And I want to cover with you a little bit of information. We've got list price and list period. We've got marketing, and then we've got marketing commencement date. So we're going to have a little bit of a discussion on this. Put in the list price, and then you fill in the date. This is the date that the client relationship begins between your public seller and your broker. You have to have an end date per license law. Now, you could, well, I'll get to that in a second. So that's the date that the client relationship begins. Marketing, you list what MLS services the property is going to be marketed in. Now, regarding an MLS service, it has in bold, all caps, delivery of agreement to and listing with an MLS. This agreement shall be timely delivered to and listed with the above referenced multiple listing service in accordance with the rules of the MLS. This obligation shall control over any conflicting language herein. Then the GAR seller brokerage agreement allows for a marketing commencement date. That is the date when the property is first marketed to the public. And the seller shall have the right to move this notice up or back by not more than so many days. So let me just give you a little bit of background why this is here. Let's say you go on a listing appointment and you have a seller and they have some repairs to do, or they have to paint one of the bedrooms that has hot pink walls and they need to, you suggest they need to paint it back to neutral. Or we've got graduations coming up. Let's say they've got a big graduation party and lots of family in town, and they're just not quite ready to have the public come in. They're not ready to show the house yet. They've just got a lot of things going on. Well, what do? Well, it used to be the MLSs have always said you have to, FMLS has always said you have to list it in their listing service within, should know this, I don't remember, it's either 24 or 48 hours after signing a listing agreement. And before this language was in the GAR listing agreement, we would sign it and not put it in the MLS until whatever, next week or whenever the seller wanted it. And GAR would get upset with the brokers and say, no, you're in violation of the MLS agreement. And we're like, yeah, but the client doesn't want it listed yet. FMLS years ago used to tell us, well, to have your agent not sign it until they're ready to put it on the market. And we said, no, we teach our agents as a broker, when you're there on the appointment and the seller's ready to go, get them to sign the document. Because what you don't want to have happen is you're there, you're on your listing agreement, seller says, yes, I love you. I know you're going to do a great job for me. I want to sign, but I don't really want it to start later. Well, you don't want to post date it because it hasn't started yet. And let's say they want to list it in 2 weeks. Well, you don't want another slick talking agent coming in there the day before they're ready to list. And if your listing agreement is post dated, you don't have anything and they could list with another agent. So to correct all of those issues, GAR has added this second date. So you've got the beginning date of the client relationship and of this all the terms of this agreement that we're going to continue to cover, but it doesn't have to be marketed until a certain date. Now, FMLS still says you still have to put it in our listing service within 24, 48 hours. Well, what do? That is where that coming soon status has come into effect. You list it now, you put it in the MLS, it's not ready to be seen by the public at all. So you put the status would be coming soon. All right. Then we're going to have another bit of a discussion on compensation. So the next section is paragraph. We're still in paragraph A, which are all the fill in the blanks. Paragraph B is the what all the blanks mean, all the legalese, what the buyer or what the seller, we're in the seller brokerage agreement, what the seller has agreed to do, and what you as the broker agree to do when when a public seller signs this agreement. So, compensation. It used to say commission. 2025, it was changed to compensation. Per the terms of the NAR settlement that was finalized in November of 2024, this paragraph here has been added. Compensation to broker is negotiable and not set by state law. I will tell you, however, your broker, and if your broker allows you as an agent, your broker is allowed to have a policy on the fees they charge for the services they provide. So, yep, it is negotiable, but my negotiation could be based on what my policy is. So just because it says it's negotiable, not set by state law, doesn't mean you have to discount your services if your broker doesn't allow it or you don't allow it. You are still allowed to have policies under which you conduct your business. Now, compensation to the seller's broker. The seller agrees to pay the seller's broker the following compensation at the closing of any contract to sell. And you fill in the blanks. Either the seller is agreeing. Now, this is how much the seller is paying you, their broker. How, let, let me ask you a pop quiz question. You as an agent, what is the document that you sign that confirms how much money you get as an agent for any real estate transaction? Type it in the chat. What is the document that you sign as an agent that confirms how much money you get for a transaction? Type it in the chat. No guesses? There we go. Commission agreement? Anybody else? What is the document that you, as the agent, as the affiliated licensee, what do you sign that confirms how much money you get paid for any particular real estate transaction? Compensation, compensation, brokerage. Ah, all right. The correct answer is your independent contractor agreement. Dun, dun, dun. I saw one correct answer. Now, I'm not saying that to embarrass anybody at all, but I want you guys to get something out of this class. I started off by saying all contracts are signed in the name of whom? Your broker. That means all documents, all brokerage agreements, all customer descriptions, all purchase and sale agreements, all the forms that have to do with compensation, they're all in the name of your broker. Compensation is earned in the name of your broker. It is all brokerage compensation. So thank you very much. You are an affiliated licensee. You are affiliated with your broker. These documents that we're covering now and all the other documents you guys named, those confirm compensation to your broker, which is very important. You need to make sure your broker gets paid because then your broker pays you by virtue of whatever agreement you have signed on your independent contractor agreement. That's one of the many things you look at when you're choosing a brokerage. You're choosing a brokerage based on how much your broker is going to pay you from the gross amount of money that the public pays your broker, as well as support and relationships and location and freedom to run your business and flexibility and all sorts of other issues. But the amount of pay, the amount of money you put in your bank account after any closing is based upon your independent contractor agreement, how much of the gross commission your broker pays you. But all these other contract forms we sign with the public, those confirm how much money the public pays your broker so that your broker can pay you. So, um, that was just a good pop quiz question. All right. So going back to compensation to the broker, and again, you guys need to negotiate this because the more your broker gets, the more you get. So this is how much the seller is paying their broker for representing them to help them get their home listed, marketed, negotiated, and sold. And the seller agrees to pay you an amount, a percent of the purchase price. And there's two fill in the blanks. One is for words, and then the other would be for numerals. Or it could be a flat fee or other. So there could be some other compensation arrangement, or this other could be something like a marketing fee, an admin fee, something like that. And again, that is dependent upon what your broker, the policies your broker has, and what your broker allows you to charge a seller, and what you and the seller negotiate. But so this top paragraph 4B, that's the money the seller pays for to your brokerage. Now, moving along, whether this compensation is paid to the buyer's broker. The seller hereby approves of the following. Select all which are applicable. Number one, not initially offering compensation to a buyer's broker, but marketing that the seller is open to receiving offers in which the seller will pay compensation to a buyer's broker. Two, compensation is being paid to a seller's broker, and they're either doing that, the seller is going to pay directly the buyer's broker, or this second option is the traditional co-op. The seller pays you a big pile of money, pays your broker a big pile of money, and your broker is directed to share. Seller's broker out of the compensation being paid. Or, so those are the two options. Number three, again, this is about compensation being paid to a buyer's broker. Number three, no compensation is being offered or marketed to a buyer's broker. So let's talk about these three things. The first thing is the seller says, so you're on a listing appointment. You're going over the money. I highly suggest as an instructor, you bring a seller net sheet, bring a couple of them, and you're going to do all sorts of various scenarios financially so that a seller can understand approximately how much they are going to walk away with at the when they sell their house and at the end of a closing. So you negotiate how much they're paying you, your broker, in this first B, in paragraph 4B. Now, the discussion you're going to have with the seller is, seller, you have the option of compensating a buyer's broker or not. It's always your option, and you can negotiate that. So, and you explain how the market works and how things work, and showing what their competition is doing, and so forth and so on. So, the first option means, what this means is, okay, the seller has agreed, yep, I'm going to go ahead and pay a buyer's broker, but you are not to disclose how much, because I don't know how much. And that amount can be a whatever percent. I'm definitely willing to compensate a buyer's broker, but I don't know how much right now. Because why? Well, it depends on the buyer's offer. If the buyer, depending on how much money they offer for the sale price, depending on if they're asking for closing costs, depending on when they want to close, depending on if they're asking for, all sorts of terms to a buyer's offer, depending on all of the terms of the buyer's offer, how much they're going to ask me to pay for their broker. So, yep, I'm absolutely going to compensate a buyer's broker, but I have no idea how much yet. till I see an actual offer. Or so that would be this first option. This second option is, yep, I'm definitely paying a buyer's broker, and I'm paying a buyer's broker X% of the sale price. Or I'm definitely paying a buyer's broker, I'm paying a buyer's broker a flat fee. So the second section, 4C2, is the seller definitely is paying the buyer's broker. So these first two are, yep, paying a buyer's broker, but not sure how much. Second one is, yep, paying a buyer's broker, and this is how much I am going to pay a buyer's broker. So you fill in the amount, and then you say, okay, seller, are you going to pay the buyer's broker directly? And if they do that, then that gets negotiated in a purchase and sale agreement, either as a special stipulation or in a variety of other compensation forms we have. Or this second option is, nope, this is the traditional co-op. So let's say, and this is a combination. Usually I don't see a combination. So let's say a seller has agreed to pay you 3 apples. These are just for examples. There are no set commissions. They're all negotiable by law and not set. I mean, all negotiable, not set by state law. But let's just say, for example, 3 apples. So the seller has agreed to pay you at the end of a deal 3 apples for doing the job. Then let's say the seller says, yep, I'm going to pay the buyer's broker 3 apples, and I'm going to negotiate that in the purchase and sale agreement itself. Again, via special stip or one of the other compensation forms. If that's what they choose to do, if you're marking this box seller directly, then it would be 3 apples here and 3 apples here. If a seller says, no, I'm going to pay you a big pile of money and you are to share that money. That is what we have done for years and years and years and years. And that's what we refer to as co-op compensation. If that's how that seller has agreed to do, you're going to put 6 apples here and 3 apples here, because the seller is paying you a big pile of money, a big bunch of apples, and they're telling you to share all the apples I'm giving you. You are to share half of them with a buyer's broker. So the way that would look, it would have a bigger number here, a smaller number here, and you would check this box, seller's broker, out of the compensation being paid to the seller's broker. Or there could be a combination, but I don't really see that a lot. I'm just kind of helping you how to fill this out. And this box down here, if seller's offer of compensation to a buyer's broker is conditional, specify the conditions. We used to see in the MLS services all the time when compensation, co-op compensation, had to be in the MLS service. Now you're allowed to put it in FMLS. You're not allowed to put it in Georgia MLS. But we used to see all the time something such as, if buyer's agent is not present on the first showing, compensation will be X versus Y. So something like that has to be approved by the seller, and this is where some sort of condition is spelled out, and that would be right here. So that's option 1 and 2 regarding buyer's broker compensation. Now let's talk a little bit about this one. No compensation being offered or marketed to the buyer's broker. This is a seller saying, right now, when we sign this listing agreement, I am thinking I'm not going to pay any compensation to a buyer's broker. A buyer is going to have to pay for compensation, their own broker compensation themselves. Now, all of that being said, if your seller chooses that option, I want to let you know now is the time on the listing appointment to have this discussion with your seller. You have to say, okay, seller, I get that. However, I am bound by license law. GREC Rule 521.10.1 says I must present all offers. So even though you are directing me at this point to not offer any compensation to a buyer's broker, if we get an offer and the buyer is asking you to compensate their broker, don't shoot the messenger. Don't say to me, don't even show me that offer, because by law, I have to show you that offer. Now, you can reject that offer, you can counter that offer, but I have to present it. Now, at the listing appointment is the time to have this discussion with your seller, because they're going to get upset if they've chosen this offer and you present them an offer where the buyer's asking for the seller to compensate their broker. Also, as I mentioned, guess what? The terms of the buyer's offer, the seller could initially think this, but the terms of the buyer's offer could be so amazing, they agree to it. So you never know, but that's what all of these mean. When I said about a net sheet, you're going to do a net sheet with all sorts of options. How much, this is pretty firm, how much you negotiate for the seller to pay your broker. These numbers, you're going to do all sorts of net sheets, all sorts of scenarios with all sorts of negotiations, different sale prices, different amount of compensation to a buyer's broker, different amount of seller's contribution to a buyer's closing costs. There's all sorts of things that you can negotiate to give a seller an idea of what they will net at the conclusion of a sale. Now, let me just bring up what these last two lines mean. For all purposes herein, the term buyer's broker shall mean the broker, including the broker representing the seller, if they are also working with or representing the buyer as a customer or client. That is there if you have both sides of a deal, whether it be a dual agency situation or both sides. What does that mean, Dana? Well, the seller has agreed, let's say the seller has agreed to pay the broker representing them as the seller this much. Let's say the seller has agreed to pay the broker working with the buyer this much. This means if you have both sides of a deal, they are still contractually obligated by virtue of this and this little last sentence right here, to pay you both of these, pay your broker both of these, one for the listing side of the deal and one for the buy side of the deal. So again, that little last sentence is in there if you are working both sides of a transaction. And then this says how much the seller is going to compensate you for a lease. Don't leave that blank. You might have a seller that has absolutely no intention of leasing their property. However, they could end up getting an offer that's a lease purchase, which is a closing with an interim lease, and you'll want to get paid at the consummation of the lease, or things could change and they could change their mind and end up leasing the property. So again, don't leave that blank. Protected period. GAR for 2025 has spelled out what is actually getting protected. The length of the protected period during which time broker shall be entitled to compensation under certain circumstances where this agreement has been unilaterally terminated by the seller or has expired, and it shall be X number of days. And then there's a description of agency, and this is the type of agency that is not offered by your broker. Lead-based paint, again, we know if the house was built prior to 78, you need to include the lead-based paint disclosure, and GAR gives us a reminder of that there. And hang on. Sorry about that. My little pup got locked in the bathroom, had to let her out. And again, this is if the house was built prior to 78, or if anything in the house could be construed as a lead-based paint hazard, meaning an antique mantelpiece, reclaimed barnwood, things like that. And then this last section where it has the seller has the following special circumstances: bankruptcy, divorce, other, and that could be like short sale or an estate or something like that. You guys, this is you only check these boxes if the seller is required, it says it up here, required to get third-party approval. Third-party approval. If they've already declared bankruptcy, if the divorce has been finalized, if the person has already passed away and the person you're dealing with, the estate has been through probate, and the person you're dealing with has been named administrator, executor of the state. If those things have already been done, you don't need to check this box. You only check these boxes if they're in the middle of a bankruptcy and the bankruptcy court has to approve the listing. They're in the middle of a divorce and the divorce court has to authorize all the terms of the listing. If they haven't gone through probate, they're in the middle of probate and the probate court has to approve the terms of the listing. That's when you check these boxes, not if those events have finalized. And then per license law, uh, I'm sorry, this is not license law. The seller does want you to negotiate on their behalf or does not. So those are all the fill in the blanks. And then, of course, we get to what does all this mean that the seller just agreed to? Well, the first thing just says, yep, they're not working with anybody else. You are the only broker right now that they're working with. And if they had been working with another broker, they did not unilaterally terminate a previous brokerage agreement without the without the consent of the previous broker. Why? Well, you'll see once a seller signs this, they are in contract with you as their exclusive broker to represent them in the sale until this agreement expires. If they terminate, they've defaulted. If they terminate and you don't agree to it, there is a way they can mutually terminate. But if it is a unilateral termination, then that is a default. And again, they can select another broker for representation. But as I said at the beginning, representation and compensation are two separate issues. So if they have unilaterally terminated or fired a broker before the end of the agreement, then they may owe that broker compensation. Now, list price again, this is what the seller agreed to. I love GAR put this in here a few years ago, and I love that they did this. The failure of the property to be shown or sell at the list price may be an indication that the list price is too high. This has not been an issue we have had to deal with in our area for the past few years, but we're circling back. The cycle is switching a little bit and we are seeing sellers reducing list prices. And if it is, there could be a variety of factors, but I love that GAR put that in here. You guys, basically, in my experience with 30 years having a real estate license, every property sells if it is priced appropriately for condition and location. Three factors: price, condition, and location. Everything will sell priced appropriately for condition and location. It used to be location, location, location. Now it's condition and location, condition and location, condition and location, and price accommodating those two. Extension. Let's talk a little bit about an extension. So basically, what this paragraph goes over is, let's say you have a listing agreement and you signed a seller brokerage agreement with the seller, and let's say it expires May 31st. So your listing agreement expires May 31st, but you went under contract, so you went under contract in May. Let's say you went under contract May 15th, but your transaction is not closing until June 16th. The closing date is after the expiration of this listing agreement. However, because you are under contract, this listing agreement is automatically extended through day of closing. So that's one extension. The other extension says, let me explain what this part means. This means, let's say we have a listing agreement. Let's say we go under contract today, May 6th. Buyer goes under contract today. They have a due diligence period. They end up terminating 4, 5. Let's say they end up terminating on Sunday, May 11th. That would be 5 days. We were off the market for 5 days. Buyer terminated. As a broker, you can extend, the seller agrees, in this paragraph right here, the listing period may be unilaterally extended by the broker for the number of days that the property was under contract. So I can add, let's say our listing agreement expires May 31st. I can add 5 days. So the new expiration date would be June 5th because we were under contract for 5 days and that fell out. However, I have to provide written notice to the seller within 5 days. So if the contract terminates on May 11th, I have through May 16th to send notice to the seller that I'm going to take advantage, and our listing agreement will now expire June 5th. So the seller has already agreed. It's a notice. They don't have to agree. They agree when they sign this, but I have to send them the notice of those number of days extension within 5 days after the termination. If I don't send that notice, then I don't get to extend it. And GAR does have a form. It is F317. Let me confirm that. I have it on the buyer brokerage. I don't have it here for whatever reason. It is F158, notice to extend brokerage agreement. That's the form you're going to use. Again, you have a listing, you go under contract, terminates under due diligence or for whatever reason, the number of days it was under contract, you can extend, but you have to send them notice. And then this marketing paragraph, basically, there's a lot of information in here, but basically this one, a couple of things I want to point out to you is whoever pays for pictures, the pictures belong to that person. So if you as the broker pay for those pictures, then they belong to you. You can use them in in your own marketing. You can use them in whatever in the future. If your seller pays for those pictures, drone videos, anything like that, then they belong to the seller. And after the sale, after this closes or the contract expires, you may not use those pictures without their written permission. Additionally, you guys, just while we're here, never copy pictures from any MLS service and use them in your marketing. All MLS pictures are copyrighted by MLS, and they're not yours to use. Liability for misinformation. This says that the seller warrants anything they tell you about the property is accurate and complete, and if it is incorrect, that's on them, not on you. This also says, hey, seller, I have no control over people walking in your home. And nowadays, everybody has a camera and a movie camera with them when they walk in your house by virtue of a cell phone. So just letting you know, I'm not liable for any pictures, photographs, or videos they take of your home. This is what we already had a good discussion about this earlier about the MLS service that says once a seller has signed this brokerage agreement, you have to list it in whatever MLS service within 1 business day. This says, I'm sorry, of the marketing commencement date that it's made available to the public. However, this is GAR's contract. If you are a member of FMLS, Georgia MLS, whatever MLS you belong to, you need to check with the membership rules of that MLS regarding when a property is to be entered into their service. And again, the different status, coming soon versus active, is what dictates when it can be marketed to the public or not. This also says we do the best we can. We put a lockbox on the property. As an instructor, I highly suggest you use a super lockbox where you can have access to who has accessed that lockbox. If you do a combination lockbox, it's a lot harder to be able to prove who accessed the lockbox or not. But regardless, this says seller, remove all your valuables because there's public people coming in your home. Compensation, we've had a pretty good discussion about how to fill that out and what those forms, those fill in the blanks were. This is just saying Seller, you are obligated to pay me what you agreed to pay my broker at closing, and optional compensation to a buyer's broker. If you agreed to pay, you agree to pay. And again, this is further confirmed in the purchase and sale agreements as well. Okay, let's have a little discussion about protected period. So, the protected period, the number of days you filled out in this paragraph, and I've seen anywhere from 30, 60, 90, 120, whatever your broker's policy or whatever you choose and whatever gets negotiated with the seller for the protection period. This says that your compensation is, well, let me just go over this. I'm going to have I'm just going to go into it. The protected period shall be the period set forth in this agreement commencing upon either the expiration or the unilateral termination of this agreement. If the seller unilaterally terminated it without your consent, then the number of days you had as a protected period, let's say you had a 60-day protection period, and let's say they terminated and there were 35 days to go. They unilaterally terminated. You can add those 35 days to the 60 days. So now your protection period is 95 days. So that's what this means. If the agreement is unilaterally terminated by the seller without the consent of the broker, the protection period is the protection period agreed to plus those number of days. Now, if you as the broker, if you mutually terminate a listing agreement with the seller, the protection period becomes 0. If you mutually terminate agreement, there's no protected period whatsoever. Again, what is protected? Your compensation is protected during, let's say it's 60 days. If you have a 60-day protection period, your listing agreement expired, you didn't get it sold. Within the 60 days after the expiration date, if the seller enters into a contract to sell or lease, as long as while your listing agreement, before it expired, while during the term of this agreement, the property was shown to any buyer, either in person or virtually, or the buyer was provided information about the property, either directly from you or from a broker working with a buyer, then and only then the seller shall pay the broker at closing. Okay. Couple of things. Agent point of practice. If you have a listing agreement, you don't get it sold and it's going to expire. You need, well, while you have the listing, you need to keep a list of every buyer that you directly showed the property to, either in person or virtually, as well as, obviously, you don't have the names of the buyers that were working with a co-op agent that came to show it, but you need to keep a list of the co-op agents that showed it. And I suggest at the expiration of a listing, you print out that list, you keep it, and you give it to that seller. And you say, if you sell it to any of these buyers during, again, in my example, 60 days, you're going to owe my broker compensation. So contact me so I can actually probably represent you. So that's what the protection period means. But you have to demonstrate it's not just any buyer. It's not, your compensation is not protected for any sale in the protected period. If there's a buyer that never saw it during those 60 days and they come and buy it, you're not protected. Again, it says during the term, for any portion of the property during which the term of this agreement was shown to any buyer, either in person or virtually, or such the buyer was provided information about the property, either directly or through a broker working with the buyer. Now, very important, I have a star. Notwithstanding the above, that means throw out everything I just said. If this agreement expires, again, unilateral termination is a default, so that's different. But if this agreement expires, the following exception to the above compensation obligation shall apply. Specifically, no compensation shall be owing to broker if the seller signs an exclusive seller brokerage engagement agreement with another broker and the property is sold or leased during the term of that agreement with that broker. Let me give you an example. You have a listing agreement with a seller. It expires May 31st. You have a co-op agent show the property on May 30th. You know it's going to expire tomorrow. The seller knows it's going to expire tomorrow. The co-op agent does not know it's going to expire tomorrow. You haven't sold the property. The seller knows their listing agreement is getting ready to expire. They've been interviewing other brokers. They have selected another broker. They've signed a listing agreement to begin June 1, 2025 with another broker. May 30th, co-op shows it, doesn't make an offer. You call the co-op, what does your buyer think? Blah, blah. Well, they're interested is between yours and another property. May 31st. This is your listing agreement's going to expire tonight at 11:59. You call that co-op agent. What do you think? What do you think? Well, they're getting really close. They just haven't made a decision. What can I do to help them make the decision to write an offer on this property? I don't know. They have everything. They're just going to think about it. It's May 31st. This agreement expires tonight at 11:59. Seller has already done their interviews. They've signed another brokerage agreement. They are now have signed binding exclusive seller brokerage agreement with another broker beginning June 1st. The afternoon of June 1st rolls around. You get an offer from the co-op agent that showed it 2 days ago. If the seller ends up accepting that offer, are you entitled to that commission, that compensation? Yes or no? Type it in the chat. Well, yeses, couple yeses, lots of yeses. Bunch of yeses. The answer is no. One no. Okay, now you can all type no because I just said it. The answer is no. Look at what this paragraph says, regardless of everything I just said. So you could demonstrate that buyer showed it while it was listed, all so forth and so on. During the term of the agreement, they saw it. You can demonstrate that. However, no compensation is owed to the broker, meaning you. Again, we're in the protected period paragraph. If the seller signs an exclusive seller brokerage agreement with another broker, and it says the exception to the above, that means all of the protection period goes out. What that means, the minute a seller signs with another broker after your agreement has expired, there's no protection. Your commission is only protected on these buyers if the seller doesn't sign it with another company. If they don't sign with anything, or they do it for sale by owner, that's the only time your commission is protected during the protection period. Don't just listen to me because I'm telling you that. It's written out right here. Notwithstanding the above, if this agreement expires, the following exception to the above, meaning no protection, the following exception to the above compensation obligation shall apply. Specifically, no compensation shall be owing to the broker if the seller signs an exclusive seller brokerage engagement agreement with another broker, regardless if that buyer has seen it or not. Now, I'll give you some hope. It is a little different on the buyer brokerage, but on the seller brokerage agreement, they don't re-sign with you. They sign with another brokerage, no protection. All right, then this section goes through brokerage, and it talks about dual agency. Again, is legal with disclosure and consent. That's what all these paragraphs are about, as well as describing what designated agency is. This is all the information about lead-based paint disclosures, as well as if there is the presence or possibility of lead-based paint, meaning if the property was built prior to 78 or anything in there, These are the seller's obligations. You, as the listing broker, are advising the seller of what they must do. Seller understands the seller must. And these are the 4 things the seller has to do. It also reminds you that you need to, if it is part of 78, the seller needs to execute the lead-based paint disclosure exhibit. And just so you know, if it is prior to 78 or lead-based paint hazard, a buyer is entitled to a 10-day period to conduct a risk assessment, and that is completely separate from due diligence should the buyer choose to do that. Okay, one thing I need to point out about the seller's property disclosure statement. There's no law that says a seller has to fill out a property disclosure statement. There is a law spelled out right here that says if the seller has knowledge of a latent material defect in the property which could not be observed by the buyer upon a reasonable inspection, even if the property is being sold as is, the seller is required to disclose that. As well as you, a licensee, by virtue of having a license issued to you by the state of Georgia, if you have knowledge of a disclosed if you have knowledge of a latent material defect that could not be observed by a reasonable inspection, you also have to disclose that. So that is the only law. However, the listing agreement states that within 3 days of signing this agreement, the seller agrees to provide the broker with a fully executed seller's property disclosure statement. And there's 3 options. There's a long option and a short option and one for leases. So it's not law that says a seller has to fill out the GAR property disclosure statement, but the contract does. But if a seller doesn't want to do that, that's fine. You just need to add a special stipulation to that effect. And I'll show you what that will look like at the end. This next paragraph, again, you know, if it's in all caps, it's pretty important. This says, seller, you have a duty to warn people and fix up any defects or hazardous conditions or repairs where it could harm the other anybody walking in here, where it could injure or harm somebody. And I don't have any duty to inspect that. So in other words, if you've got rotten flooring, or if you've got a basement downstairs and the first step is the floor, the tread of the stair isn't there, the handrail, anything that can be dangerous, you have to fix it, and you have to warn somebody of it. And this part goes on here, this limit of broker's authority and responsibility. This says, I am a real estate agent. I am acting within that capacity of a real estate agent with you as my client. I, however, have no duty to inspect the property, advise you of anything which could be revealed through survey, appraisal, wood infestation report, utility bill, septic. A lot of this stuff applies to buyers too, because GAR uses the same paragraph in the buyer brokerage agreement. But for sellers, it could be if it was a good investment or not, a financial planner, mortgage consultant, tax consultant, so forth and so on. Basically, if there's something that is of significance to you or really important to you, you have a duty to go check it out with an expert in that area. I have to make all disclosures required by law. In other words, I can't keep any secrets specifically about latent material defects because I have a license and I have to tell those. You are responsible for being complying with all duties and deadlines. And then this is important too. No authority to bind seller to any contract. I think this is more for agents than for our public. Agent to agent communication means nothing. If you as an agent are negotiating with an agent representing a buyer, and the buyer writes an initial offer, and a lot of us old timers end up negotiating, like we write an offer, we negotiate verbally, and then write it all up. If an agent says a seller is willing to do something, or if an agent says a buyer's willing to do something, it does not bind the party to terms. No agent or broker has any authority to bind the seller to any contract. It has to be in writing, legible, and signed by the seller for it to be enforceable upon the seller. That's also in the buyer brokerage agreement. Limits on the buyer's broker's liability. Seller acknowledges no liability greater than any commission paid or $100. And this is about Georgia residential mortgage fraud. If there's any issues, there's arbitration. Assignability, that is not for investors. That means if the brokerage sells their brokerage to another, to somebody, that the listing agreement automatically goes to the new buyer of the brokerage. Any attorney's fees, if there is a court, there are any attorney's fees. If there's a dispute, the seller has to pay that. Broker shall mean the licensed Georgia real estate broker, meaning the person who's the qualifying broker of your firm, the actual firm company in and of itself, and you, the affiliated licensee. So when these forms use the word broker, it means all three. This is a brand new law that came out in January of 2024 that basically states that Georgia prohibits certain non-resident aliens, foreign persons, foreign companies, and U.S. companies owned by any of the above from buying or possessing agricultural land and certain land within 10-mile radius of a military base, military installation, or military airport. Again, this is not for you to get involved with. Get them with an attorney. And just so you know, there is a new GAR consumer brochure 29. Along with that is the FERPTA affidavit, again, regarding to a foreign person buying property here in Georgia. This is saying what the GAR forms are. And this also says, okay, seller, you are responsible for making sure that the form is used, meets your specific needs, if there's any special stipulations written, so forth and so on. It doesn't matter where the seller is when they're signing it, or a buyer is when they're signing it. The laws of Georgia prevail over this contract, as well as the timeframes in Georgia. Third party event compensation survives the agreement. 1-year statute of limitations if they're going to try to sue you for make a claim against you regarding a breach of this agreement. Third party vendors. I love this. Broker does not warrant or endorse the performance of any such vendor, and the names of vendors are provided solely as a courtesy and starting point for a seller to identify possible vendors, perform services on behalf of the seller. This is in the buyer brokerage agreement too. This is great. These are what the broker's duties to the seller are and what the seller's duties to the broker are. This is where it talks about default. And again, I've said it, this will be the third time I think I've said it. Compensation is different from representation. So if a seller terminates this agreement prior to the end of the agreement, that constitutes a default, and they potentially owe you compensation, even though you're not representing them anymore. Additionally, if they fire you or they terminate this and you don't agree, you're still going to obviously take down your signs and take it out of the MLS services. But what GAR added is that is not evidence of your agreement to mutually terminate. And there's a misconception out there. There are some sellers or some agents that have been practicing for a while that believe that if a seller gets a full price offer, they're required to take it. That's not true. Nobody can force a seller to sell their home. Now, a judge in a specific performance lawsuit can say, yes, seller, you have to go through with the contract. But by virtue of a public person signing a listing agreement, they're not required to sell their home. However, A seller is in default if they don't accept a contract. And what it means is they agree to pay you compensation if they refuse to accept a lawful bona fide written offer, as long as that offer contains all of these terms: purchase price after all fees and seller contributions, and ad valorem taxes at least full price or more, no contingencies whatsoever, and it closes between 30 and 45 days. So there are very specific things that a seller, again, is not obligated to sell, but if they get an offer that meets all of those terms and they don't sign it, they would owe you commission, your broker compensation. And if the seller defaults, they shall immediately pay broker compensation. And if they default, meaning if they fire you or unilaterally terminate, it does state that the seller shall immediately reimburse the broker for all their out of pocket costs and expenses, and shall also pay all costs, fees, and charges that for removing the listing service from any MLS. Now, this is in here, but enforcing that might be a different issue. But the seller does agree to compensate you. So you should keep track of all your costs and expenses with any listing. Warning about cyber fraud. You guys, cyber fraud is a huge issue in our industry. And all the brochures, again, as an instructor, I highly suggest you use all the appropriate seller brochures that GAR has to offer: ABCs of agency, lead paint, if that's applicable, mold, radon, protect yourself when selling real property. You should always use that one, so forth and so on. And then a list for exhibits. Now, a couple things before we leave this. Again, the seller is not required by law to complete the seller's property disclosure statement, but they are required by this contract. So if a seller does not want to, you're going to add a special stipulation that says, per paragraph C1, the seller chooses to not complete a seller's property disclosure statement. That's all you need to say. And says the seller is agreed, understands, and acknowledges, and then they sign it. If they are a trustee, if it's an LLC or something like that, GAR has added in 2025 how they are to sign this. They sign it, fill it in, and you sign it, fill it in. Now, I will tell you guys, please, your brokers, on behalf of all your brokers, please put in an email address or phone number as well, so that if something were to happen to you, you're not available. And as the broker, I have to get in touch with the seller. I need contact information. You would do it on this, the seller brokerage agreement, not necessarily on a client, but your broker needs to be able to get in touch with your public seller. Now, a couple things, hang in there with me before we take a break. First, sneak peek of what is coming out as a revision in the seller brokerage agreement. Then we're going to go over the seller customer description, and then we'll take a break and we'll be done with sellers. So this is the mid-year revisions. You guys are the first to see this. Exclusive seller brokerage agreement. These revisions are going to be live for y'all June 1st. And the first one is in response to all of the issues going on with NAR, which I'm not going to get into, but I'm going to just show you what GAR has added. This paragraph under paragraph B3, delayed marketing. Again, this is in direct response to an NAR new provision regarding delayed marketing. Our MLSs have a little bit different because we've got the coming soon status. But in the GAR exclusive seller brokerage agreement, it does state, seller understands and acknowledges that if the seller is delaying the public marketing of the property, seller may not maximize either the number of offers the seller receives or the price offered to buy the property. Seller nevertheless knowingly waives the potential benefits of immediate public marketing. Brand new, coming out in June. And one other thing that is coming out in June is they've added two parts to limit on broker's liability. This is going to be in the buyer brokerages too. The seller shall have no liability for providing, I'm sorry, broker shall have no liability for providing information that later turns out to be incorrect or false, provided that the broker did not have actual knowledge that the information was false and discloses to seller the source of the information. And this limitation of liability shall survive the termination of this agreement. Again, those two are added to the buyer brokerage agreement as well. So those are the only mid-year changes coming out to the seller brokerage agreement. Now, hang with me. We're going to go over one more form and then we will take a break. So, where'd it go? Again, in Georgia, the client relationship is contractually driven. By default, a public person working with a broker is a customer, but GAR has agreements that describe the customer relationship. So the listing agreement, exclusive, the seller brokerage agreement, exclusive and non-exclusive, create the client relationship. The authorization to show unlisted property, GAR F-107, describes the customer relationship. And again, you fill in the name of the brokerage, you fill in the date, beginning date and an end date, you fill in the property address and the legal description. All of that's the same. You fill in a list price. Now, what's different is you're going to identify potential buyers now, and it does say you can update this list at a later date. Fair housing disclosure, and I'm sorry, that was in the listing agreement as well. Compensation. This, in the event during the term of this agreement pursuant to the above authorization, the broker procures a buyer or tenant ready, willing, and able to purchase the property at the price described above, or another price acceptable to owner. Owner agrees to pay the broker the following compensation. That's how much an owner agrees to pay you. There's no compensation for a buyer's broker because you're not listing it. This is generally speaking, you're really working with the buyer already, and they find a house for sale by owner, or well, I'll give a couple of scenarios there. But anyway, it's just compensation that the owner pays to your broker for selling the property. Protection period, all of that is filled in for the number of days for the party you bring. All of that is the same. All of that is the same. All of this is the same. Here's where it says this is a customer, just describes the customer relationship. Paragraph B15. No brokerage relationship between the owner and the broker. This agreement shall not be construed to create a brokerage engagement between the owner and the broker, but is rather limited to the owner's permission to give the broker to show the above property to prospective buyers and tenants pursuant to the above authorization in exchange for compensation to a broker as set forth above. The parties understand and agree that the owner is the broker's customer, and that as such, the broker may perform ministerial acts, which we went over at the beginning of class, for the owner. It is understood that this agreement in no way prohibits, fancy word for just prevents, the owner from selling or leasing the property directly to a buyer or tenant other than the ones that we're working with listed above, or subsequently provided by the broker to the owner. Owner shall retain the right to enter into a listing agreement concerning the property with any other real estate broker. And again, the rest of this is the same as what we have already covered. It does refer to this person as the owner rather than the seller. So again, a couple of uses of this form. If you are already working with a buyer and there is a for sale by owner that they want to see, you would ask the for sale by owner to sign this authorization to show unlisted property. Additionally, let's say you have a previous client or a neighbor or somebody that you know of, you're working with a buyer, and you know this person is going to put their home on the market soon and it would meet the needs, suit the needs of your buyer, then you would work it in that situation. Another use of this form is, let's say you have a past client or just somebody you know, it doesn't have to be a past client, and um they are they know you and they're going to sell their house, but they already have a buyer. Let's say they're selling it to a friend or a child or a neighbor or something like that, and they call you up and they say, "Hey Dana, guess what? I'm moving. I'm going to sell my house, but I'm selling it to my neighbor. I just need somebody to help me write it up and take it to closing. Can you do that?" Yes, you could do that. That would be another reason where if you chose to work with if the buyer may have had their own agent, or you could work with both parties as customers. The seller would sign this authorization to show on listed property describing that customer relationship, and the buyer would sign the customer acknowledgement agreement to work with a broker, which will show after break. So that is the seller side of the brokerage agreements and the customer broker seller as customer. Let's take a quick All right, everybody, welcome back. Are there any questions before we knock out the rest? If so, type them in the chat. Don't see anything. All right. All right, I'm going to share my screen. We're going to continue on with the buyer documents, and then we're going to talk just a little bit about compensation with respect to the brokerage agreements. So let me share my screen and we shall dive in. So this is the exclusive buyer brokerage engagement agreement. It is GAR F110. And we're going to go a little bit quicker through this one because a lot of the pre-printed verbiage that we had a really lengthy discussion about in the seller brokerage agreement also applies to the buyer brokerage agreement. It's just that we're working with a public buyer rather than a public seller. So the first thing is, as I've repeated many times throughout this class, is that the client relationship between a public person and your broker is contractually driven in Georgia, and there is the law that states that. So for a public, by default, your public are your customers. If they want to be a client, they would sign a brokerage engagement agreement. So this is for the buyer side. And again, this is an exclusive buyer brokerage agreement. So this is the buyer warranting that they have only signed an exclusive brokerage agreement with you, and they're not a party to another exclusive brokerage agreement. And same thing, you fill in the actually, I'm pull up the chat. Let's see questions. You fill in the terms of this agreement, beginning date and an end date. You indicate the types of agency that your brokerage does not offer, and compensation. So this is a little bit different. Let's have a good discussion. This is going to be the majority of the discussion on the buyer brokerage agreement. So the word commission has been changed to compensation. And again, per the terms of the NAR settlement that was finalized November of 2024, GAR has added this paragraph: compensation to brokers is negotiable and not set by law. And as I've already previously addressed, a broker and an agent, if your broker allows you, are allowed to have a policy. You don't have to discount if it is against your policy. So negotiable does not equal discount. It depends on what your policies are and the terms that your buyer, they've chosen you. And if they choose to work with you, this is the terms under which you will work with them. Compensation to broker. Buyer agrees to pay broker the compensation set forth in the value of broker's professional services section below, at the closing of any contract. Value of brokers' professional services. In other words, when you are working with this person as a buyer, the value of your services are the following. This is how much you can get paid in total, regardless of who is paid. This is two things. Number one, how much the buyer is going to pay for your services representing them in the buy side of a transaction. Number two, this is the amount that your services are worth representing this buyer in the buy side of a transaction, regardless of who is paying it. So I'm going to go through that a little bit more, but there's two things that this number represents. So the value of brokers' professional services. Again, that amount is expressed either as a percent of the sale price, and it has two fill in the blanks, one for words and one for numbers, or flat fee. And then there is another section, other, and that would be something again, such as an administrative fee, retainer fee, anything like that, that would go there. So again, this amount represents two things: the buyer's financial obligation for the buy side of a transaction, and the maximum amount a broker may receive for the buy side of a transaction working with this buyer, regardless of who is paying for it. So this is how much a buyer owes. Now, the next thing says, okay, and it says right here, buyer agrees to pay. This is a financial obligation on behalf of the buyer. And this is how much it's going to be. But it says possibly this amount of compensation can be paid from the seller side of the deal, either from the seller directly or from the seller's broker, in what we traditionally have referred to as a co-op arrangement. So this says the buyer directs or does not direct the broker to seek the seller or seller's broker to pay all or a portion of the broker's compensation, as long as it does not exceed the broker's compensation above. I just mark direct because I cannot imagine a situation, unless perhaps an investor, maybe that's the only thing I can imagine, but other typically than an investor, I would think that the majority of the rest of buyers are going to ask you, their broker, to try and get the money that they owe you paid for by the seller side of the deal. But again, remember, it has this provided it does not exceed the value of the broker's compensation above. That's why I wrote my little note here. If the seller or the seller's broker agrees to pay all or portion of the broker's compensation, it shall reduce the compensation the buyer shall pay the broker dollar for dollar. So in other words, whatever amount you fill in here, if you negotiate, if the buyer asks and the seller agrees and you negotiate for the seller to pay your broker some compensation for your services, if it's less than this amount here, then it gets subtracted. So in other words, let's say the buyer has agreed that your services working with them for the buy side of any transaction are 3 apples. What this says is if it gets negotiated and the seller's willing to pay 2 apples, you take 3 apples that they've obligated themselves to pay, you subtract the 2 apples you're getting from the seller side, and at closing, they will only owe 1 apple. If they've negotiated that your services for the buy side of a transaction working with them are worth 3 apples, and they negotiate and the seller side is compensating you 3 apples, then the 3 apples of their financial obligation minus the 3 apples you're getting from the seller side equals 0. They will owe $0 at closing. So that's what that means when it says, shall reduce the compensation the buyer shall pay dollar for dollar. Now it goes on to say, Disclosure regarding broker's compensation. Buyer shall be obligated to pay all of the broker's compensation not paid by the seller or the seller's broker. Therefore, before making an offer to buy or accept a counter offer in a contract to purchase, the buyer should confirm number one, any contribution that the seller or the seller's broker is making towards the broker's compensation, and two, that the buyer has the financial ability to fulfill its compensation obligation. Buyers should not make an offer to buy or accept any counter offer in a contract to purchase that will result in the buyer paying more of the broker's compensation than they can afford to pay. And then again, there is separate compensation for a lease. So
Excuse
there's
me.
a lot packed into this paragraph. Again, the two key things are this amount is the buyer's financial obligation to pay for representing them in the buy side of a transaction, and this is the maximum amount your broker may receive for the buy side of a transaction working with this buyer, regardless if it is coming from the buyer or from the seller's side, either from the seller directly or the seller's broker. All right, protection period. And again, you fill in the number of days. And the same thing about assignment. That's if your broker goes out of business. So, couple of notes on this compensation paragraph up here. It cannot be zero. This is per the terms of the NAR settlement that was finalized November 2024. It cannot be zero and it cannot be free. You cannot in any way indicate that a real estate broker's services for the buy side of a transaction are free. And it can't be zero, can't be free. It cannot be open-ended. You can't write in there whatever the seller side is willing to pay. Cannot be open-ended like that. Another note I have for you, you'll want to check with the lender when they're doing their pre-qualification. You want to make sure that the lender also checks for the buyer's compensation obligation when qualifying that buyer. This amount up here also must include bonuses. Here in Metro, there we go. Where do you put the builder's bonus to a selling broker? So here in Metro Atlanta, a lot of our new construction builders are offering bonuses to a buyer's broker. So a couple things. If you fill in right now, when you are first meeting, and there is extra work that does typically go into working with new construction. So a couple of things about bonuses. If when you're first meeting with a buyer and you fill in a percent of the sale price, and then here you would write a bonus not to exceed, it can't be open-ended. So again, there's a question here. It can't be whatever bonus the builder's willing to pay or the seller's willing to pay. You have to put, for example, a bonus not to exceed X amount of dollars. It has to be a specific amount or a topped out different amount. But if when you're first meeting with a buyer and you fill that out, the buyer's obligated to pay that. So the buyer would be obligated to pay whatever percent of the sale price plus a bonus. You might be hard pressed to get a buyer to sign that. You could perhaps get with your broker. You could perhaps write something that specific to new construction. Um, but how else would you deal with a bonus? Well, I have a note down here that you may amend the buyer brokerage agreement to reflect a change in circumstance or a change in fee for professional service, i.e., new construction, or if there is a bonus offered. If there is a bonus offered, there is a change in a circumstance. You can articulate there is a change in circumstance. And so, what you would do is you would first meet with a buyer and fill in this information without any information, any compensation obligation regarding a bonus. If they find a property that is offering a bonus, you would do an amendment. Again, check with your broker. You would do an amendment to the buyer brokerage agreement that says, and you would reference the specific property. So you would do an amendment to the buyer brokerage agreement that would say something to the effect of, at the closing of 123 Lucky Street, buyer agrees per paragraph A4 that buyer's broker is allowed to receive a bonus of X amount of dollars in addition to the compensation of whatever percent, or an additional bonus of X amount of dollars, and have the buyer sign it. So you would amend the buyer brokerage agreement. Now, a couple of things. Number one, you're definitely going to reference a specific property. Don't put it in general, because if that deal falls through and they find another house, it could be different. The second thing is, you would also do an amendment. Let's say the buyer has agreed that your services are worth 3 apples. They find a house, they negotiate with the seller. The seller agrees to compensate your broker 2 apples. Your broker is fine with receiving that as total compensation. If you don't do anything, then at closing, the buyer is still obligated to pay your broker 1 apple. You could also do an amendment that says, again, with respect to paragraph A4, buyers at the closing of 123 Lucky Street, buyer's broker agrees to accept in total compensation 2 apples paid by the seller side, and buyer owes an additional 0 apples at closing. So you can do this amendment to change this compensation either up or down. Again, please get with your broker. The other thing, back to the discussion about bonuses, is if the seller is offering a buyer's broker bonus and the buyer has not allowed it, you can't accept it. So you have to do an amendment. What conversation that may prompt is dividing up that seller side bonus, some of it going to your broker and some of it going to the buyer to be used in as a credit for them at closing. So there's all sorts of other changing circumstances that do occur when the seller side is offering a broker bonus. So I hope that answered that question. All right. Then again, we get to paragraph B, which is all the description or the legalese regarding everything the buyer just agreed to. And again, it says that they warrant that they are they're not a party to another exclusive buyer brokerage agreement, or one that they have unilaterally terminated, meaning defaulted on and might owe that other broker a bonus. Extension, this is the same as we discussed in the seller brokerage agreement. Let's say our buyer brokerage agreement expires May 31st, but our closing isn't until June, whatever date I said. Let's just say the closing, we expire the 31st, and let's say the closing is June 11th. Well, the buyer brokerage agreement automatically extends through closing, 11:59 p.m. day of closing. Or same thing, let's say you're working with a buyer, they write an offer on a property and they end up terminating under due diligence. Let's say they're into it and they terminate 3 days based on due diligence. This buyer brokerage agreement automatically gets extended for those 3 days that they were under contract, but you, as the broker, the agent for the broker, you have to give them written notice within 5 days of that termination, and you're going to use the GAR form F158, notice to extend brokerage agreement. If you don't give them the notice within that 5 days, and that's just written out here, within 5 days, then there's no extension. And then same thing, we've talked about agency brokerage, dual agency disclosure, what designated agency is, so forth and so on. These paragraphs go on to talk about what we just had that lengthy discussion on regarding compensation. Buyer is obligated to pay the broker's compensation referenced herein at the closing, and buyer's compensation obligation shall exist Even if it occurs after it's expired, buyer shall additionally be responsible for paying compensation if the buyer defaults. And then it goes on that says there are times when the seller or seller's broker may offer to pay the buyer's compensation obligation to the broker, but it's not always a done deal. It talks about buyer's compensation obligation if they buy a for sale by owner, and is separate on the lease. Okay, now let's talk about the protected period. This is different from the protection period on the listing agreement or the seller brokerage agreement. Protected period shall be the number of days set forth in the agreement commencing upon the expiration of this agreement, or what would have been the expiration had it not been unilaterally terminated. So again, if the buyer unilaterally terminates or quote unquote fires you, if you had, for example, a 60-day protection period and there were still 30 days left on the buyer brokerage, your protection period is now 90 days. Those number of days left automatically get added if they unilaterally terminate. Same thing if there's a mutual termination, there's no protection. But what is protected? You guys are going to like this. What is protected is properties that were shown to the buyer by the broker, either virtually or in person, or which the buyer otherwise visited. Those are protected properties. Then the buyer shall owe the broker at closing or the prior commencement of the compensation for a lease. So, what does all this mean? When this buyer brokerage agreement is intact, any properties that you show the buyer either in person or virtually, or this part here where it says where buyer otherwise visited. Sometimes a buyer will, for example, go see new construction. We'll go see new construction, and you contacted that on-site agent, and so your buyer's protected, but you weren't physically there. So any of these properties, if your buyer brokerage agreement expires and they go back and buy one of those properties, your broker is entitled to compensation, even if they sign a new buyer brokerage agreement with another broker. So in this situation, the protected properties, you are protected for compensation. Again, even if they've signed a buyer brokerage agreement with another broker. However, you need to keep a list of these specific properties and give them to the buyer at the expiration of this agreement. So again, this is a little bit different from the seller brokerage agreement regarding a buyer choosing to work with another broker. And then it goes on to describe what the broker's duties are to the buyer and what the buyer's duties are to the broker. And again, it talks about exclusivity, disclosing if they've worked with another broker. Again, this is all in here because it's trying to prevent the buyer from being obligated financially to another broker that they are not working with. And then this same paragraph that we discussed in the seller brokerage agreement, broker's authority and responsibility. All this paragraph basically states is if there is anything of really importance to the buyer with regards to any specific property, it is the buyer's responsibility to go seek an expert in that area. You are an expert as a real estate agent, but you're not a surveyor, you're not an accountant, you're not a roofer, you're not an inspector, you're not an appraiser, you're not a tax consultant, you're not a zoning expert, so forth and so on. So if there is something that is, if that's a concern of the buyer, they have the duty here to go check it out. And it says, you have no duty to inspect the property or advise the buyer of hazards or anything else. Um, Again, same thing, no authority to bind, limit a broker's liability, and just like on, well, I'll get to that in a second. Again, the disclosure about Georgia mortgage fraud. You don't want them going to jail, and you don't want to go to jail by being a party to mortgage fraud. Any disputes on this agreement are to go to arbitration. If they lose, the prevailing party, means the winning party, is entitled to get its attorney's fees from the loser. Same thing, broker means your actual qualifying broker, the brokerage, the company, and you as affiliated licensee. This is something different. This was really prevalent the past couple of years here in Georgia when we had a hyper market, not a seller's market, but a hyper go to plaid market, straight to plaid. Some of you will get that reference. Buyer buying property sight unseen. Broker hereby advises buyer that there are significant risks in buying property sight unseen, since pictures, videos, and other information about the property may not accurately reflect the true nature and condition of the property or the area in which the property is located. Therefore, if buyer purchases the property sight unseen, buyer agrees to indemnify and hold broker harmless from any and all claims, suits, damages arising out of or relating to any issue that the buyer or buyer's representatives, other than the broker, would have reasonably observed had the buyer visited the property and the surrounding area. Definition of a buyer and a seller, and I'm sorry, that was in the seller's one too. It means their family, so forth and so on. And again, this new law that we discussed in the seller brokerage agreement that came out in July of 2024 regarding a new Georgia law prohibiting non-resident aliens, foreign persons, or foreign companies from buying any land within a 10-mile radius of a military base, installation, or airport. For all those definitions, refer to there is the law, and I highly suggest you get your buyer with an attorney. And same thing with the fair housing disclosure, the GAR forms, everything is in with respect to Georgia law. And this part was in the seller brokerage agreement too. I didn't put that in here, but it's in the purchase and sale agreements too. This sentence here where it says, if any of the provision in any of our agreements is held unenforceable, it doesn't throw out the whole contract. Just that one part gets severed from the agreement and the rest remains in full force and effect. Hazardous conditions on the property and hold harmless. Okay, buyer, we are walking into strangers' houses. I haven't seen them. You haven't seen them. We have to be careful. There could be things we don't know about. There could be rickety stairs. There could be, I don't know, something that could cause us injury or damage. Be careful and be on alert and don't sue us. That's what this says. You agree to hold us harmless. Statute of limitations, 1 year, all this. I'm going very quickly because we've discussed all of this pretty in depth in the seller brokerage agreement. Same thing with the third party vendors. If we go under contract and you ask me for an inspector or surveyor or a home warranty, I will be more than happy to provide more than one of these vendors, but I do not warrant, broker does not warrant or endorse the performance of any such vendor, and the names of the vendors are provided solely as a courtesy and a starting point for a buyer to identify possible vendors. Buyer default, again, if a buyer defaults under this seller brokerage agreement, they owe you money. Representation and compensation are two separate issues. Cyber fraud. This is especially important with buyers. Point of practice to you as an agent. Do not email wire instructions to your buyer, either from your broker or a closing attorney. It is our emails that are getting hacked. And you tell your buyer you will not email wire instructions. What do? You guys, wire instructions don't change a lot. Go print out a bunch of wire instructions from your broker or your favorite closing attorney and keep them with you in paper. And when you're meeting with your buyer, physically hand them those wire instructions. But advise your buyers not to trust any wire instructions they get in email or in a text message, especially if there is a change, and to verify from a third party. This is in the buyer brokerage agreement and not in the seller brokerage agreement. This is a huge issue in Georgia for the past couple of years. I imagine throughout the country, but I'm only familiar with Georgia. This is warning the buyers regarding identity theft and indemnification and covenant not to sue. Buyer acknowledges that there is an increasing amount of identity theft involving persons impersonating sellers of a property and attempting to sell property they do not own. This is particularly the case in the sale of lots and vacant properties. You guys, this is a huge ongoing issue. If you are an agent and if you're working with a seller and it is vacant land and they called you out of the blue, I have a whole video on my YouTube channel, Real Estate Made Crystal Clear, steps you can take and check with your broker, check with your attorneys to verify the actual identity of that seller. You definitely want to meet with them in person or some sort of virtual visual context and get copies of identification. If you're working with a buyer and your buyer is writing an offer on vacant land, you as the agent, you are going to want to ask the listing agent what steps they took to verify the identity of the actual seller. Did you know the seller? Did they call? How did they get your name? What steps did you take? It is a huge issue, and these bad guys are out there trying to bilk people out of money. It is especially prevalent with lots, land, and vacant properties. What the GAR buyer agreement goes on to say is basically they are very sophisticated. We do the best we can. You agree not to sue us, to indemnify us. And buyer is strongly, if you do go through with the sale, buyer is strongly encouraged to purchase an enhanced title insurance policy on any property buyer's buying to protect them for the risk. Again, get your buyers with your closing attorneys to understand the various title insurance policies. And then again, the brochures, I suggest you use all that are appropriate, any special stipulations and signatures. And again, please make sure your brokers get contact information for your buyers. We need their email address, their phone number, their address. Doesn't have to go on a contract, but please put it on your brokerage agreement so we have them. Mid-year changes hot off the press for the exclusive buyer brokerage agreement. Again, these are coming out June 1st. Not a lot. It's under the liability section that we already discussed in the seller brokerage agreement. It's under paragraph B3. This verbiage has been modified regarding that the broker is to be held harmless by the buyer during and after the termination of this agreement from all claims. Again, inaccurate information, earnest money handled by anyone other than the broker, injury, and buyer's negligence or wrongdoing, so forth and so on. And they have also added that the limit of broker's liability shall survive termination. So those are the only, I think that's it. Those are the only changes coming out in June. And again, you'll see it says June 1st to the buyer brokerage agreement. All right, let's cover the GAR form F116 that describes the customer relationship if how to get the forms for class. Yep, I'll show that in just a minute, Jackie. Describes the customer relationship. I'm going to put it in the chat too. So hang on, everybody. I am going to add in the chat where you can get the handouts. And I am also going to attach in the chat a copy of the handouts, that package, and you can just download it right there from the chat. So hope that helps everybody. Okay, moving along, the agreement to work with buyer as a customer, again, doesn't create the customer relationship. That's done by default. It just describes it. So you're working with a buyer. They want to work with your broker as a customer, which we know means you can perform ministerial acts, but not use your discretion or judgment. Fill in the date. You fill in the name of the buyer, the name of the brokerage, And it says it right here, first paragraph, agreement to work with buyer as customer. Buyer hereby agrees to work with the broker in locating real property to purchase suitable to the buyer's needs. In working with the buyer's broker shall not be representing the buyer as a client, but shall only be working with the buyer as a customer. As a customer, the broker cannot represent or advise the buyer on brokerage matters as a broker would be able to do if the broker was representing the buyer, but can only perform ministerial acts on behalf of the buyer. The term client, customer, and ministerial acts shall have the meaning that they have in the brokerage relationships and or Beretta laws. And again, I at the beginning of the class, I showed you what those are. And then you fill in the and I suggest you print that out and give it to the buyer so they understand what ministerial acts are. Don't just use our code or lingo or jargon, but let them know exactly what they are. You would want to know that. And then you fill in the term of the customer relationship. Compensation. Generally, compensation to brokers is negotiable, not set by law. Buyer agrees to pay buyer's broker the compensation set forth in the value of the broker's professional services below at the closing of a contract. This is the value of the broker's professional services for working with this person on the buy side of a deal. Possible reduction. Again, buyer says, okay, broker agent, I want you to try to get my financial obligation to you offset by the seller. And if you do whatever they agree to pay, regardless if it's coming from the seller directly or from the seller's broker, get subtracted from my obligation dollar for dollar. Buyer shall be obligated. This is the same stuff we have talked about. When is compensation due? Buyer shall be obligated to pay buyer's broker's compensation referenced above that was shown or identified to the buyer during the term of this agreement, even if the closing is after or within X number of days of the expiration of this agreement. Definition of buyer and seller, definition of a contract to purchase, what a buyer agrees to do, and fair housing disclosure. Same thing regarding the new law regarding foreign companies owning land within a 10-mile radius of all the military issues, GAR forms, statute of limitations, cyber fraud. Same warning about bad guys representing sellers of land and lots and vacant properties. Arbitration, all of this is the same that we've discussed. The biggest difference is the customer relationship as well as the brochures. And again, when working with a customer, let me say one thing. When working with a customer, they've still chosen you and your brokerage to work with. The only difference is the legal nature of the relationship that governs your communication and what you can do for them is different. But they're still your customer. You still need to honor them and respect them and treat them as a customer who's chosen you. You still providing these forms for them is still a ministerial act. And you co-op agents, if you get an offer, you listing agents, let's say you get an offer and under the agency disclosure at the bottom of the purchase and sale agreement, it says ABC Realty is working with buyer as a customer. That does not give you permission to cross the sign and directly go and communicate directly with that buyer. Number one, that's a license law violation. It's an unfair trade practice. And you still have to respect that that public person still chosen that person and that brokerage with whom to work. So just wanted to bring that out. And then again, it says buyer acknowledges they've read, they understand, and they're voluntarily agreeing to sign it. And if it is an entity, this is how they are to sign, and they sign it. So that's the buyer as customer. Any questions on that before we continue on? All right. I have got another pop quiz. You guys are hating my pop quizzes. Another pop quiz question. I want to talk briefly about the non-exclusive seller brokerage agreement, which is GAR F104, and the non-exclusive, F104. This should be buyer. The non-exclusive buyer brokerage agreement, which is GAR F113. Here's my pop quiz question for the chat. If you are working with a public person and they sign a non-exclusive either seller brokerage agreement or buyer brokerage agreement, are they a client or a customer? Type in the chat. Public person signs a non-exclusive seller brokerage or buyer brokerage agreement. Are they a client or a customer? Mixed bag on this one. The correct answer is they are a client. Remember, our Beretta law says if a public person signs a brokerage agreement with the broker, they are a client. The difference between an exclusive brokerage agreement and a non-exclusive brokerage agreement, if it's an exclusive brokerage agreement, that means they agree to be a client just of your broker and nobody else for that time frame. If they sign a non-exclusive brokerage agreement, that means they agree to be a client of your brokerage and of the next brokerage and of the next brokerage and of the next brokerage. It does create the client relationship. It's just that it creates it with more than one broker. And that is described here. So a couple of things before I go on reading the GAR form. FMLS and Georgia MLS. Again, I'm not familiar with the other MLSs, but those two MLSs, if a public seller has signed a non-exclusive seller brokerage agreement, that listing is not allowed to be in FMLS or Georgia MLS. FMLS and Georgia MLS will only allow a broker to list a property that has signed an exclusive seller brokerage agreement. Now think about it, that makes sense. You know, when you go to the MLS services and you find a listing, you see who the listing broker is, so you know who to contact and to get information and whom you're going to be dealing with. If a seller signs a non-exclusive seller brokerage agreement with more than one, it can't go in the MLS service because you're going to see it under different brokerages. Which broker are you going to deal with? So that just makes sense. But the non-exclusive brokerage agreements still legally create the client relationship between the public person and your broker. It just can't go in MLS. But here's what it says. This is the seller, GAR F104, the non-exclusive. Seller has full authority to enter into this non-exclusive agreement for the listing of seller's property for sale. Under this agreement, seller shall have the right to list the property for sale on a non-exclusive basis with other Georgia licensed real estate brokers and to sell the property directly without the assistance of a real estate broker. This agreement may not be amended except by the written agreement of the seller and the broker. That's in all of them. The failure of the parties to adhere strictly to the terms and conditions shall not constitute the right strict adherence. Seller is not a party to any other exclusive seller brokerage engagement agreements, and all previous agreements, if any, have expired, so forth and so on. But again, this creates a client relationship between a public seller and a broker, and a seller can sign more than one non-exclusive seller brokerage agreement simultaneously. And then basically who gets paid? Well, whichever broker is procuring cause of sale brings about a buyer, that's the one that gets paid. Protection period is the same, but it does add no compensation. Well, it's the same thing as we've said. And then the non-exclusive, this should say buyer. The non-exclusive buyer brokerage agreement, GAR F-113, same thing. It just says foreign in consideration with mutual promises contained herein, other good and valuable consideration, hereby enter into this non-exclusive buyer brokerage agreement. So again, it creates the client relationship just with more than one person. And what that does is that dictates the nature of the interaction between you and the public person. So let's cover, we're going to finish on time. So let's cover just a little bit more about the new world of compensation with respect to these brokerage agreements and customer agreements. Let me start off by asking you, how is a seller's, how many ways, let me do this. How many ways is a seller's broker paid? And how many ways is a seller's broker paid? Type in the chat. Okay, this one's going to be tricky. How many ways is a buyer broker paid? Put in number dash seller number dash buyer. How many ways is a seller's broker paid, and how many ways is a buyer's broker paid? I'm getting pretty deep, but we're towards the end. We're pretty deep. All right. I'm getting a mixed bag of answers. So let me share my screen again, and this will be really clear when I go over it. How is a seller's broker paid? Generally speaking, there are always exceptions, but generally speaking, a seller's broker is paid one way. A seller's broker gets paid from the seller. How is that if the seller is a client of the broker, that all gets described and agreed to and spelled out on the exclusive seller brokerage agreement if they're a client, or the non-exclusive seller brokerage agreement if they're a client. If they're a customer, that gets all spelled out so you know how much on the authorization showing list of property. But generally speaking, a seller's broker gets paid one way from the seller. Buyer's broker, however, there are three ways, or combination of the three ways, a buyer's broker gets paid. A buyer's broker gets paid directly by the buyer, or the buyer's broker can get paid from the seller's broker in a co-op compensation arrangement that we've done for years and years and years, or the buyer's broker can get paid directly from the seller. So a buyer's broker can get paid from the buyer. If the buyer is a client, then that is spelled out and negotiated and agreed to on the exclusive buyer brokerage agreement. If they're a client, it could also be on the non-exclusive buyer brokerage agreement. If the buyer is a customer, that is negotiated, spelled out, and agreed to on the agreement to work with buyer as a customer. And again, the buyer side compensation is a little different. Not only is that how much the public buyer agrees to pay their broker for the buy side of a deal, that is the maximum amount a buyer's broker can get paid for the buy side of a deal working with that buyer. But that's all spelled out in the buyer if the broker's getting paid directly by the buyer. The second way is a buyer's broker can get paid in a co-op deal from the seller's broker. Where does that get spelled out? That gets spelled out on either the pre-showing compensation agreement, a buyer's broker's compensation agreement exhibit, or the instructions to closing attorney. That's it. That's where you're going to see written out how much a co-op deal is that the sellers paid the seller's broker a big pile of money, and the seller's broker is sharing part of that pile with the buyer's broker. You're going to know how much of that pile a buyer's broker is getting on one of those three forms, as long as it doesn't exceed what's on here. Or the buyer's broker can now get paid directly from the seller. That is going to be spelled out somewhere in a purchase and sale agreement, either as a special stipulation or on the buyer broker's compensation agreement exhibit. Now, technically, a buyer's broker could get paid directly by the seller, and that would be spelled out on the pre-showing compensation agreement. But that's rare that that's going to happen, because usually a seller is not going to agree to a specific amount prior to showing, pre-showing. Usually they're going to wait and see a buyer's offer. And again, sometimes on the instructions to closing attorney, or with a closing cost contribution. So briefly go over, got another handout for you. Is there a question? Just chatter. Okay. Mute everybody again. All right. This is a table I have for you. And if you have been practicing lately, if you've seen these forms, these will make a little more sense. If you haven't done a deal since January, this might be really, really confusing, but please do not let it confuse you. This is just a table for reference for you. It will make sense once you're actually involved in a deal. So again, that other previous handout, this is just a summary of broker compensation with respect to the actual GAR forms. So broker's compensation is this first column. The financial and the seller, see, we only have one column for the seller, because the seller's broker only gets paid one way, from the seller. Buyer's broker, we have 3 columns, because a buyer's broker can get paid one of 3 ways, or a combination of these 3. So how to read this table is of the financial obligation is created. So the broker's compensation is created, and this is the foundation, and other forms have to match this. Consumer financial obligation. So the financial obligation is created from the party to the broker. For a seller, it is created on the F-101 exclusive seller brokerage agreement, or F-104 non-exclusive seller brokerage agreement, or F-107 authorization to show unlisted property. That's it. It's not confirmed anywhere in a contract. It is summarized. I'm going to make a special exception to the instructions to closing attorney. So give me a minute. I'll cover that in a minute. But the financial obligation is summarized to a seller's broker on the instructions to closing attorney, but it's only on a client document or a customer document. Now, the buyer's broker side, again, buyer's broker can get paid 3 ways. The financial obligation is created, again, in either the exclusive buyer brokerage, non-exclusive buyer brokerage, or agreement to work with customer. So that is the foundation where the financial obligation to the buyer's broker is created. Where is it confirmed? Financial obligation is confirmed. The form's based on who is paying, and the party paying must sign the form. So compensation to a buyer's broker is it's established here, and it is confirmed either on a pre-showing compensation agreement, or the buyer's broker's compensation agreement exhibit, or the instructions to closing attorney if it's coming as a co-op deal, or if the buyer's broker is getting paid directly from the seller. That is all written out, agreed to, signed, and confirmed on either the pre-showing compensation agreement, but that's not typical, because usually a seller paying a buyer's broker directly will wait and see the offer. So they're typically not going to do it on a pre-showing compensation agreement. Or the financial obligation to a buyer's broker getting paid directly by the seller is confirmed on the F-259 Buyer's Broker's Compensation Agreement Exhibit or Special Stipulation 620, or there is a provision in a seller's contribution to a buyer's closing costs where any overage can go towards the buyer's broker, or instructions to closing attorney. And then the last row I have here is where is the financial obligation summarized? And all of those are the instructions to closing attorney. So, one comment as an instructor, check with your own broker, but as an instructor, I highly encourage you guys, wherever the compensation to both brokers, the seller's broker and the buyer's broker, throughout a purchase and sale agreement and a contract, wherever that is negotiated, agreed to, spelled out in writing, whether it be on a pre-showing compensation agreement, buyer's broker compensation exhibit, special stip, blah, 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 wherever it is, I highly encourage you guys to still use the instructions to closing attorney for a couple reasons. Number one, it will summarize the compensation to the brokers on one page. It will say the seller's broker is getting paid X amount of dollars, and who's paying it? The seller. The buyer's broker is getting paid Y amount of dollars. Who's paying it? Well, it's either coming from the buyer, it's coming from the seller's broker, or it's coming directly from the seller, or combination thereof. But the instructions of closing attorney are still a really good summary of all the compensation. It keeps everybody on the same page. It keeps both agents on the same page. It keeps buyers on and sellers on the same page. It keeps your brokers on the same page and your closing attorneys. Let's face it, when you send a contract to a closing attorney's office, it is a pre-closer who is trying to sort through all the information and create a preliminary HUD statement, including who's getting paid what. Well, with all of the new forms we have recently, sometimes it's a little tricky to see who's getting paid what by virtue of what. And we typically don't send a buyer brokerage or brokerage agreements or customer agreements to a closing attorney. And if there's compensation on a pre-showing agreement, that's not part of a contract either. So again, I highly encourage all parties, all of y'all, to use the instructions to closing attorney up front early to avoid any crazy issues. There is a question. Yes, that form is also included in the handout package that I have to you. And I will stay on to answer questions, but I do want to thank you all. Remind you to confirm all contract questions with your broker. Check out our calendar for additional courses. And I've shown you where you can get all the handouts, and this class is being recorded. So as soon as I get the recording up on my YouTube channel, Real Estate Made Crystal Clear, you can watch this again. I do record the CE classes I teach virtually. You can't get 3 hours CE just watching it, but it is a good reminder of something you may have missed. And I will just encourage all of you guys to please continue to be a blessing with the real estate license you have earned. Don't listen to the news if it puts you in a bad mood. There are still lots of buyers and sellers out there, and they need your services. Don't worry about the global statistics. Don't worry about the statewide statistics. Don't even worry about the city statistics. Can you go find one public person to help today with real estate with their needs? I think so. Focus on one a day, two a day, three a day. That's all you need. Don't worry about looking at something, if it doesn't put you in the proper energy, in the proper state of mind to go, we all need a roof over our head. Shelter is a basic human need, and you are in a position to help people with that basic human need. So go find someone to help. And we are at the end. I will stay on and answer questions, but I do hope that I have achieve my goals of the 3 hours going by very quickly, the CE credits as a bonus, that you did learn something that you can actually use in your practice. And I hope that I was a good reflection of the Holy Lord up above, and bless your time here spent with me, and encourage you guys to go be a blessing to your public. So before you sign out, please type in one last time name, license number, email address, and I thank you so kindly for and respectfully for your time. If you have any questions, feel free to unmute yourself as the chat is now going by very quickly. Thank you, everybody. Any questions?
Hey, Dana. I have one.
Hey, Rose.
When you talked about the designation agent being a designation agent, maximum one have several companies in one, so and different brokers.
So let me just answer that generically, because there's lots of agents from different brokerages. If you are with a company and your brokerage has either a variety of franchises, or your company, there are a lot of companies here in the Metro Atlanta where you as an agent have the choice of choosing to be a realtor and belong to a board of realtors, or choosing to practice by not belonging to a board of realtors. And that depends on, if your broker belongs to a board, then you have to belong to that board. If your broker does not belong to a board, you can't belong to a board. There are many companies throughout Metro Atlanta, and perhaps all of Georgia. I'm just familiar more with Metro Atlanta, where there are companies, and sometimes it looks like it's one company, but it could be actually on paper two separate companies, a realtor company and a realty company. Those entities on paper with GREC, with the MLS services, with the Georgia Secretary of State, they typically are two separate companies. With GREC, it's usually two separate companies. So even if it has a similar trade name, it is a separate company. So if you are an agent in a company, and you're working with a co-op, or there's another agent and the trade name is similar, but it's not exactly the same, that is not a designated agency situation. That is a completely separate brokerage with a completely separate broker, a completely separate GREC firm number. So how do you know? Well, you would ask the agent, but you would look up the down and dirty way is, if you found it in an MLS server, you can, well, actually FMLS, you can search an agent too. You would look up the agent and look up their broker code. If their broker code in FMLS or Georgia MLS is different from your broker code, it's not designated agency, it is single agency. If you can't find that, you can look it up in GREC. And if the GREC firm number is a different firm number, regardless of a similar trade name, it is single agency. It is a completely different company, regardless of any similarity of names. Did that help?
Yes, it did. Thanks.
You're welcome.
Hey, Dana, I have a question.
Yes, sir.
So, what happens in case of a buyer where they are saying that the compensation will be paid? It's a co-op deal. Your compensation as a buyer agent should be fully paid by seller slash co-op, and we don't want to pay you anything. You said it cannot be zero. It cannot be, you cannot say open-ended. So how to handle that situation where buyer says, I don't want to pay because you will be paid by co-op.
Okay. So if you put zero if you put $0 or 0% in the buyer brokerage agreement, how much can you get paid from the seller side?
0.
0.
Oh,
So you have,
yeah,
right? So the first thing to explain to the buyer is you're not going to work for free. Number one, because you are providing valuable professional services. Number two, if you're a realtor, it's against the realtor terms of the NAR settlement, so you're not allowed to. But
sure. If
you
you are
have to
not,
put in. So you have to put in an amount. So you go through what I went through. You have to put in an amount that the buy side of a deal working with this person is worth. And that is the maximum amount you are allowed to get paid, regardless of who's paying it. And then GAR had it in that verbiage. It says, if the buyer doesn't have the money to pay you, that's a different conversation. But if they choose, let's just say they choose not to pay you, then you show that if you can find out how much a seller side is paying before you show, that's great. If not, so you ask the buyer, okay, buyer, here's a house that meets the criteria of what you want to see. I have no information if the seller side is paying any money. Do you want to see it? Yes or no?
okay.
And
But
what does
in
the buyer
case,
say? Let's say they're like, no. Let's say, okay, you can't find any information from any seller. I want to see this house. Let's go see it. Okay, great. You go show a buyer a house. You go into it blind. You have no idea if or how much compensation the seller side, whether it's coming from the seller directly or the seller's broker, is paying for your services working with this buyer in this transaction for the buy side of a deal. Buyer sees it, they love it, they want to write an offer. In this situation, you write the offer and the buyer asks the seller to pay your full compensation that they agreed to in the buyer brokerage agreement. You ask the seller either as a special stip and use that GAR SS 620, buyer asks seller to pay buyer's broker X% of the sale price. This is not intended to alter any compensation they've agreed to pay their own seller. And then if the seller says yes, if the seller signs it, you go under contract, great. What the buyer agreed to in the buyer brokerage agreement minus what the seller side is paying is 0. If that's 0, the buyer owes nothing. If you write that and the buyer in the purchase and sale agreement, in the offer, asks the seller to pay you, their broker, the amount of money they're financially obligated to you for, let's say the seller comes back and says, no, I'm not paying any of it. Well, the buyer doesn't accept the counteroffer. The buyer goes and finds another house. Or let's say the seller counters back and says, I'm not going to pay all of it. I'll pay part of it. Then you ask the buyer, okay, are you willing to pay the remainder? If the buyer says no, then you don't accept the counteroffer. You go find another house. Or your broker can decide, okay, we'll take whatever amount the seller side is paying, and you do an amendment to the buyer brokerage agreement like we discussed. But the buyer, you cannot fill that out with 0 because then you can't get anything and your services are worth something. But a buyer is never obligated. The buyer writes an offer asking the seller to pay it, just like closing costs or whatever. If the seller makes a counter offer, the buyer doesn't have to accept it. Does that help?
okay. Yeah, okay. One more scenario, but if you know that the commission you are going to get up from a seller / co-op, if that percentage is known, and you are writing an exclusive buyer brokerage agreement, then how do you fill that information? Now you are not saying 0 because you know that in this particular case.
So are you just going to show the buyer that one house where you know
Correct.
how much?
Correct. Yep.
Then if you and your broker are willing to accept that, then you put that amount in.
I see. Okay. Thank you.
Or like I said earlier, you would feel if you don't know, let's say you're not buying one house, but you don't know you're going to go see more than one house, you would still put the maximum amount that you would like to get paid, compensated for the buy side of a deal. And then again, you see a house, you know in advance before you show it, and you would get the pre-showing compensation agreement signed, and at that point you would do an amendment to the buyer brokerage agreement that says at the closing of 123 Lucky Street, buyer's broker agrees to accept whatever percent from the seller side, buyer owes $0 additional dollars. But if you're just
Oh.
showing one house and you know what the co-op fee is, or the seller's going to pay directly, you could just write that in.
Okay, thank you.
Does that help?
Yep, thank you.
You're welcome. Any other questions?
Not from me.
Hi.
Thank you.
Thank you.
You are
Bye.
so welcome.
Bye.
Good to see you, Rui.
Thank you.
All right, everybody.
I was trying, hello?
Hello.
Hi, this is Jackie. So, I went on to the stuff you said to show, the forms and stuff.
Mm-hmm.
Okay, I have another class this evening. What happened was I put my license inactive for a little while.
Okay.
So now before I reactivate it, I think it's good for me to know the different changes and stuff that's going on. Well, to me, it makes sense. But I went on to what you said. I looked up, I went onto the academy. I clicked on course handout and videos.